You hired an HR person because you thought they'd handle all the employee stuff so that you don't have to worry about it. Makes sense, right? But here's the reality check. HR professionals are fantastic at their job, but they're not attorneys. And when employment law gets complicated, that gap can cost you serious money. I'm about to show you real situations where well-meaning HR departments made simple mistakes that turned into expensive legal disasters. More importantly, I'll teach you exactly when to bring in a labor lawyer before things go sideways. By the end of this video, you'll recognize the red flags that could save your business from a six-figure lawsuit. Let's get started. Let's talk about Sarah. She's a marketing coordinator who's been with the company for 3 years. She goes to HR and says, "I'm really struggling with anxiety and depression. My doctor says I need some time to get treatment, but I'm worried about my job." HR's response? "We all get stressed sometimes. Maybe try taking a long weekend and see if that helps. Just power through it. You're stronger than you think." 6 months later, Sarah's performance declined. She was terminated and she filed a disability discrimination claim. The settlement? $75,000 plus legal fees. Here's what HR missed. The moment Sarah mentioned her doctor and treatment, this became a potential disability accommodation issue under the Americans with Disabilities Act. What should have happened? Ask about specific limitations. What challenges are you facing at work? Explore accommodations. Would flexible hours help? What about working from home some days? Get medical documentation if needed, and document every conversation. Instead of dismissing mental health concerns, HR needed to start the interactive process. Basically, a conversation about how to help Sarah do her job while managing her condition. The correct conversation could have saved $75,000. Here's a story from a busy restaurant chain. They had 3 shift supervisors who worked 50 to 55 hours per week. The owner paid them salaries instead of hourly wages, thinking this would save money on overtime. These supervisors spent most of their time taking orders, making food, and cleaning, just like the regular employees. But because they occasionally told other workers what to do and kept tabs on them, the owner called them managers. When one supervisor quit, they filed a wage claim. The result? $15,000 in unpaid overtime for just that one employee. But here's the kicker. The other 2 supervisors joined the lawsuit. Total damages, $45,000 in back pay, another $45,000 in mandatory penalties, plus another $30,000 in legal fees and penalties. The lesson? Paying someone a salary doesn't automatically make them exempt from overtime. The law looks at what they actually do. Do they hire and fire people? Do they make important business decisions? Do they manage other employees as their primary job? If they're mostly doing the same work as hourly employees, they probably need overtime pay, no matter their job title. Let me tell you about Maria. She's a cashier at a busy retail store. When she was about 6 months pregnant, she asked her manager if she could have a stool to sit on during her shifts because standing for 8 hours was becoming painful. The manager said, "Sorry, company policy says cashiers have to stand. It just looks more professional. Maybe you should consider taking early maternity leave." Maria worked in pain for 2 more months, then filed a pregnancy discrimination complaint after her baby was born. The company settled for $35,000. Here's what they got wrong. Under the Pregnant Workers Fairness Act, employers with 15 or more employees must provide reasonable accommodations for pregnancy-related limitations. A simple stool would have maybe cost $50. Instead, the company's rigid thinking cost them $35,000. Here's some common pregnancy accommodations that are almost always going to be reasonable. A chair or stool for jobs that require standing, more frequent bathroom breaks, help with heavy lifting, flexible scheduling for doctor's appointments, a clean private space for pumping breast milk. The key is treating pregnancy accommodations the same way you'd treat any other medical accommodation. If you'd give someone a chair for a back injury, you need to do the same for pregnancy. Here's a costly mistake I see everywhere. A construction company hired 5 workers as independent contractors to avoid paying payroll taxes and benefits. These workers worked only for this one company, used the company's tools and equipment, followed the company's schedule, wore company uniforms, and got trained by company supervisors. When the state labor department investigated, they ruled these were actually employees, not contractors. The penalties were brutal. $25,000 in unpaid payroll taxes, $30,000 in workers' compensation premiums, $15,000 in unemployment insurance, and $10,000 in penalties and interest. The total cost? $80,000. Plus, they had to reclassify all the workers as employees going forward. The test for contractors is simple. Do they work and answer to you like employees? If yes, they probably are employees, regardless of what your contract says. Real contractors work for multiple clients, use their own tools, set their own schedules, have specialized skills you don't necessarily have in-house. So when should you pick up the phone and call a labor lawyer instead of just asking HR? Call a lawyer before making decisions about whether someone is an employee or a contractor, whether someone qualifies for overtime pay, any accommodation requests such as for disability, pregnancy, religious reasons, harassment or discrimination complaints, firing someone who's mentioned medical issues, writing employment contracts, or severance agreements. Think about it this way. A 2-hour consultation might cost $800, but fixing a mistake after it becomes a lawsuit can cost $80,000. Your HR team is valuable. They handle the daily people management that keeps your business running, but they're not trained to interpret complex federal laws or predict how courts will rule. The winning combination? Let HR handle the day-to-day employee relations, but bring in legal expertise for the high-stakes decisions. Look, these expensive mistakes don't happen because business owners are careless. They happen because employment law is complicated and it changes constantly. But here's what I want you to remember. Every single one of these disasters was preventable with the right legal guidance at the right time. Don't wait until you're facing a lawsuit to get help. A small investment in legal advice today can save you tens of thousands tomorrow. If this video helped you spot even one potential problem in your business, it was worth watching. Thanks for tuning in. And remember, if you need help with any of the topics I just went over in the video, click the link below. Thanks for watching.